Welcome back to City Education, your home for knowledge in all forms, shapes, and sizes. In today's video, we'll be diving into a very interesting concept in environmental law, the principle of public trusteeship. Now, it is important to note that some resources are too important to be left to private ownership alone. In South Africa, this principle of public trusteeship recognizes that the state acts as a guardian of vital natural resources, not for itself, but on behalf of the people, present and future. Public trusteeship is a doctrine that reshapes the way we view natural resources. It tells us that some resources, like water, minerals, and biodiversity, are so essential to life, dignity, and the common good that they cannot be treated as private commodities or low. Instead, the state acts as a trustee or fiduciary. This is not ownership in the private sense, but a stewardship role. The state must manage these resources prudently, sustainably, and equitably, always remembering that the real beneficiaries are the people, both present and future generations. This principle does more than protect the environment. It concerns individual property rights, recognizing that unchecked private control can lead to overexploitation, degradation, and even monopolization of resources. Without trusteeship, we risk the so-called tragedy of commons, where short-term private gain leads to long-term public loss. At its core, public trusteeship places a legal and moral duty on the state to balance needs with conservation, ensuring today's needs are met without sacrificing tomorrow's rights. Now let's look at the legislative embodiment of this principle. The principle of public trusteeship is not only a moral idea, it is written into South Africa's laws. Several statutes expressly recognize the state's duty to act as a custodian of natural resources. A National Environmental Management Act, NEMA, sets the tone. Section 2, subsection 4, paragraph O, declares that the environment is held in public trust for the people, and its use must serve the public's interest. This reflects the constitutional vision of intergenerational equity. The Mineral and Petroleum Resource Development Act, MPRDA, goes further. Section 3, subsection 1, states that mineral and petroleum resources are the common heritage of all South Africans, with the state as the custodian. In the landmark case of Agri SA, Minister of Minerals and Energy, the Constitutional Court confirmed that private ownership of mineral rights are abolished. Instead, the state now allocates mining rights in its custodial role, managing minerals for the benefit of all. The National Environmental Management Biodiversity Act explicitly calls the state the trustee of biological diversity. This means that government decisions on biodiversity conservation must be guided by the duty to protect ecosystems as part of our shared heritage. The Integrated Coastal Management Act takes a similar approach. It provides that coastal public property, such as beaches, the seabed, and coastal waters, belong to the citizens of South Africa and is held in trust by the state on their behalf. No one may privatize these areas. They must remain accessible and protected for all. Even in policy, the Environmental Management Policy (EMP) of 1998 confirms that government accepts the duties implied by the public trust doctrine. Together, these laws embedded trusteeship across different resource sectors: oil roast, biodiversity, water, and the coast, ensuring that stewardship is not optional, but a legal obligation. While national law sets the framework for trusteeship, it is municipalities that make it real in people's daily lives. Section 156 of the Constitution gives municipalities executive authority over crucial services like potable water supply, sanitation, waste management, and municipal health services. This means that local governments are the frontline guardians of public trusteeship. Their role is threefold. Firstly, implementation. National policies on water quality, waste management, and air pollution are meaningless without local enforcement. Municipalities monitor water quality, run waste disposal sites, and ensure clean drinking water reaches households. The second role is public participation. Now, as the sphere of government closest to the people, municipalities are uniquely placed to involve communities in environmental decision-making. They hold public meetings, listen to residents' concerns about pollution or service delivery, and incorporate these voices into local planning. This makes trusteeship democratic and participatory. The third role is equitable access. Municipalities are constitutionally mandated to provide basic services to all residents, not just wealthy suburbs. Whether it's clean water to rural areas, waste collection in townships, or air quality management in industry hubs, municipalities fulfill the equitable access component of public trusteeship. In this way, Section 24 of the Constitution sets the national duty, while Section 156 empowers municipalities to carry it out daily. Together, they ensure that the principle of public trusteeship translates into a tangible protection and benefits ordinary people. Now, municipalities are not only service providers, they are constitutional actors with enforceable duties under the principle of public trusteeship. Courts have repeatedly confirmed this responsibility. In South African Human Rights Commission versus Insinusi Local Municipality 2021, the High Court found that the municipality failed to act against unlawful waste burning and pollution, which violated residents' rights under Section 24 of the Constitution. The judgment highlighted that municipalities must take proactive steps to secure a safe and healthy environment. In the Fuel Retailers Association, with its Director General Environmental Management 2007, the Constitutional Court stressed that sustainable development is a constitutional principle that applies at all levels of government. Municipalities, as the closest sphere to the people, must integrate social, economic, and environmental concerns when granting local authorization. Together, these cases demonstrate that municipalities are more than administrative managers. They are trustees in their own right, constitutionally and judicially bound to protect the environment, promote public health, and ensure fair access to essential resources. Now, while the principle of public trusteeship strengthens environmental protection, it has sparked tension with private property rights. The doctrine implies that certain resources like water, minerals, and biodiversity are not subject to absolute private ownership, but belong to the public, with the state as the custodian. For landowners and businesses, this shift can feel like a loss of right. Critics argue that trusteeship could justify uncompensated infringements, undermining the constitutional protection of property. The courts have grappled with this sensitive balance. In Agri SA versus Minister of Minerals and Energy, yet again, former mineral right holders argued that the abolition of their ownership amounted to expropriation, but the Constitutional Court disagreed, holding that the state was not acquiring property for itself, but assuming custodianship for the nation. This was regulation, not expropriation. Similarly, in National Water Act cases like Mazibuko, the court confirmed that flowing water cannot be privately owned. The riparian landowner, taking more than their fee share, commits a statutory offense, not cessed. This shows that trusteeship reshapes traditional private rights in favor of collective management. Yes, the issue remains contentious. Scholars warn that trusteeship could open the door to regulatory overreach,
where the state limits
this private is so extensive that owners lose effective control. This raises the question, at what point does regulation cross into deprivation? The main challenge is ensuring that trusteeship fulfills its purpose without eroding constitutional guarantees. Courts have so far leaned towards protecting the state's custodial role, but the debate remains unsettled. Public trusteeship, therefore, sits at a crossroads of environmental justice and property rights, constantly negotiating the line between private interests and the common good. Now, public trusteeship is more than protecting resources. It's about developing them responsibly. The state has a duty to guide resources in a way that benefits everyone, not just a few people. This means promoting renewable energy, supporting sustainable agriculture, and ensuring communities have access to water, land, and energy. It's also about empowering communities to participate in decisions affecting their environment, creating opportunities for local development while respecting ecological limits. Public trusteeship is thus developmental stewardship, balancing growth, equity, and sustainability. Importantly, it acknowledges the need to redress past injustices.
In essence,
The doctrine of public trusteeship reminds us that the state is not the owner, but the guardian of our shared natural heritage. Its duty is to ensure that today's youth does not rob tomorrow's generations of their right to life, dignity, and a healthy environment. If you found this video helpful, make sure to like, share, and subscribe. And don't forget to comment so that we can engage. This is City Education, your home for knowledge in all forms, shapes, and sizes.